So in terms of agency law, we missed this one little piece, which is about the competition. You will see this again later in the course, but I want to introduce it to you now because it is an important concept. So as an employee, okay, you should not be competing with your employer, right? We have this duty of loyalty. Doesn't that seem to make sense? And because of that, a lot of employers put in place this thing called a non-compete agreement. Now I want to talk to you about it. Who in here has had to sign a non-compete agreement before? Anyone? All right, who in here knows the sub place Jimmy John's? Come on, I only have like 5. Okay, there we go. We got some Jimmy John fans? Okay. So Jimmy John's asked their employees to sign a non-compete agreement. And what they're saying is, if you work for us and you make these subs, you cannot go and work for, let's say, Subway and make subs there. And so they'll have you sign an agreement saying that. Now that's a little silly. Jimmy John's, they didn't uphold that agreement in court. They had a lawsuit recently about it. They did not uphold it, and generally they don't. Okay, these non-compete agreements are hard to enforce because that seems unfair, right? Doesn't that seem not fair to you? Like you learn, you have experience in a sub shop, and then you can't go work at any other sub shop. So in general, the law wants that competition, so they don't enforce these very often. There's certain factors they'll look to based on precedent to decide whether or not it's reasonable, and then they will enforce it. So they look to time, they look to geography, they look to the subject matter, and then they also look to the public interest. So in terms of time, to be valid, they want to make sure that it's not an unreasonable amount of time. In Maryland, we look to precedent, prior cases, and they've decided a reasonable amount of time is 3 years or less. If it's 5 years, is it reasonable? So they can't restrict you to work somewhere else for more than 3 years in Maryland. It can vary in other states, of course. So I want to give you an example as we walk through these. I talk about Raptor Tank all the time because I'm one of the co-directors. I'm a big fan of our Raptor Tank program here at Montgomery College. One of our finalists a couple of years ago, she owned a tutoring company called Modern Muse. She still does. She had a non-compete agreement because she used to work in Bethesda at another tutoring company. And so she learned about how to be a good tutor. She got good training from them. She learned their business model. And their concern is they didn't want her to go out and compete with them, right? So they have her sign an agreement that she won't open another business, basically doing her own tutoring to help monitor that competition. So in terms of time, it was less than 3 years, it was reasonable. Geography, they said, you cannot work anywhere within, it was 10 miles of Bethesda, where they were located. Why do you think they would do that? Restricts like 10 miles of Bethesda.
Consumers.
Say me one more time.
Consumers.
The consumer is the market, right? If you own a Bethesda tutoring service, who are you generally having as your client? Bethesda kids. Okay, so if she leaves that Bethesda business and goes and opens her own, if they restrict within that 10-mile radius, it's a pretty big restriction in this area, right? And you're really hitting like maybe even DC or Virginia, depending on where you are in Maryland. So really it's a big restriction, and we're a very urban area. We have a large population in some of these. But generally, if it's that region or based on common sense, they'll say that's probably reasonable. Okay, so they were allowed to restrict because it could hurt their market. She learns from them, she goes and opens the business, and then it's hurting their ability to gain those customers. The next piece is a little more complicated, the subject matter. Could they restrict this woman from doing, instead of tutoring, let's say, making subs?
No.
Why not? That seems crazy, right? Why not? Go ahead, Javon. Yeah, it's a different industry. So that's the idea of the subject matter. Like, that doesn't seem fair, right? You're not going to be taking away your, people who want sub customers. It's a different business. So you want to be careful about restricting only the specific business. And then down here, this other one, the public interest, is also a little complicated. The example I like to give is when we're thinking about how to best serve the public, there are a lot of very rural areas where there aren't a lot of doctors available, okay, especially on some of the Indian tribe locations, really, I call them the boonies, in the forest where I grew up, in these small towns, they don't always have like a town doctor, and so they might have 1 or 2 people within a half hour available to help the people in the town. And so if you have 2 doctors at the same practice, one of the doctors has the other sign a non-compete agreement, and the second doctor quits, and they're not allowed to work, you're left with how many doctors in that town? 1. So what happens if that doctor is having an emergency and he's out for a month. Yeah, Javon, you're dead. You don't have health care, right? So it's we're laughing, but it's a serious problem, especially in some of these rural areas. And so they want to consider the public interest as well. Like, will this be harmful to the public to restrict them from working somewhere else? So they'll generally look at these 4 factors. They'll look at prior cases to determine if, based on those 4 factors, the agreement is reasonable, and often they won't uphold it. They'll say, you know what, like we support competition in the United States, so please do that. So that's the idea of a non-compete agreement. And again, we'll see this again later on in the class. Now,